Okay, everyone. So we'll just do a short introduction of this presentation. And in the meantime, I'm sure more people will be joining. Hi, Lauren, civil rights attorney. Yes. So thank you so much for being here and for being willing to be educated about your rights at work. This is kind of a crazy time because our economy is reopening, but at the same time, our schools are not running on the same schedule. So we're in this really complicated situation where we have kids at home, we're expected back at work. Some of us are still working from home and it's becoming really difficult. And a lot of us are wondering what's going to happen? What happens to our jobs? How do we keep our jobs? How do we protect our jobs? How do we protect our healthcare? How do we make sure our kids are attended to and feel safe and protected? And how do we also protect our sanity? Because it's a lot, it's a lot to deal with not having childcare and trying to keep your job. So this is going to be a presentation mainly about the new FFCRA and then also about pregnancy rights. The FFCRA is a new bill that addresses specifically the school closures and caretaker unavailability due to the pandemic, the Families First Coronavirus Response Act. And I really want to think about this because it's a Families First Coronavirus Response Act. The whole intention of this act is to put your families first. So I really want you to remember that Families First Coronavirus Response Act. It is a paid leave law. And that's actually the first paid leave law in the history of the US. And it's also the first law that really puts parents in a protected class. So that's super exciting. And we're hoping that people will use the law so that it becomes permanent, that it becomes a part of our economy that we will rely on. It's actually a temporary law, but we really want to make sure that people use it. So the second part of the presentation will be about pregnancy rights, maternity leave rights, and safety rights. My name is Daphne Dalvo. I'm an employment rights attorney in San Diego, and you may know me from Instagram, where I am the mom attorney, and my mission is to empower parents to be educated about their rights at work so that they can protect their careers without compromising their family life or their health, and their mental health, because it's very difficult sometimes, that friction between our demands at work and our demands at home. So the FFCRA went into effect April 1st, 2020 through December 31st, 2020. And it's really crucial that we remember that this law is not a lockdown law. So it didn't just address the situation where everyone was home. It also addresses the situation right now when we're expected back at the office. It's still in effect. It can still be used through December 31st. Right now, the HEROES Act is being negotiated, which has a intention to extend this act, but we don't know yet because the senators are actually not too amenable to it. So we'll see if it will be extended, but as of now, it's still in effect. There's two major parts to the law: the emergency sick leave and the emergency family leave. The emergency sick leave gives you 80 hours paid at 2/3 of your pay for school closures or child care unavailability. And then the emergency family leave also gives you 12 weeks off, 10 of those paid for school closures and childcare unavailability. It's a very hastily drafted law. It's very rushed, so it's a little messy, but under both of these laws, you can actually, both of these prongs, you can actually take time off when you have kids at home. The emergency sick leave has 5 other reasons, including a lockdown order, having coronavirus. We're not going into these today. We're only going to address school closure issues. It's important that you know that you can only take the leave if you don't have childcare options due to the pandemic. So if your summer camp that you set up for your kids is canceled due to the pandemic, you can take the leave. But if you didn't plan anything for this summer, you can't just take the leave because you have no childcare. You really have to be able to show your employer, this is my plan and it's no longer there for me, or there's low enrollments and I won't be able to send my kids there as I intended. The emergency sick leave. So people who have worked for their employers for 1 day can take it. So this is different than like the Fmla, where you need at least a year. It's very exciting. So anyone who's worked there can take this emergency sick leave. You can take it whether or not you're teleworking. So if you're working at the office or working at home, if you're unable to do your job, you can take the leave. It's 80 hours or the part-time equivalent. So it includes part-time workers, Danielle. And you can take it for 6 reasons. And the pay is 2/3 with a maximum of $200 a day and $2,000 in total. Your employer can then recoup that money through their state taxes. They can actually deduct these costs, so they do get all of the money back. And that's something you maybe want to explain to your employers, because a lot of them don't know that, and they might be a little scared that this is going to be really expensive. And you want to explain, actually, you recoup all of that money, so it's not as much of a burden as you thought. The second part is the emergency family leave. So this is for employees who can't work or telework. You need to have worked there at least 30 days, and you can take it for 12 weeks and only for one reason, which is a school closure or caretaker unavailability due to the coronavirus emergency. Same pay. The first 2 weeks are unpaid, then it's at 2/3 maximum $200 a day. You can take both, but only for a total of 12 weeks, because you can take both for the same school closure, and then it will look like this. The first 2 weeks will be paid through the emergency sick leave, and the next 10 weeks are paid through the emergency family leave. So what you want to ask your employer is, hey, I want to first take the emergency sick leave and then the emergency family leave. Because if you just ask for emergency family leave, you're not going to be paid for 2 weeks. So the first 2 weeks have to be sick leave and then emergency family leave. They're not making it very straightforward or simple, but unfortunately, not everyone is covered. This is the main frustration for me as an employment attorney. The Act doesn't include private employers with more than 500 employees, that's a lot of people. So only employers with less than 500 employees, private employers, are actually eligible, as well as all public employers. So state, county, city. Also, healthcare employers and emergency responders may exclude workers. They don't need to, but they may choose to. Small businesses with less than 50 employees may exclude workers if it would jeopardize business viability. And this is actually a pretty high standard. They can't just say, oh, this doesn't apply to us. They actually have to prove that granting you the leave would be an extreme measure that would pretty much cause the business to crumble. So you can take the leave for any biological, adopted, foster, or stepchild. The definition of child is very broad, but it does have to be a minor. You can take it for any sort of child care structure that's closed. So it's not just schools, it's also daycare facilities. It's also preschools. It's before and after summer programs, it's homes, summer camps. So this is super important going into the summer with our schools closing. You can take the leave if your summer camp is no longer available, as well as summer enrollment programs. You can also take the leave if your nanny, babysitter, au pair, your mother, mother-in-law, neighbor, whoever watched your child is not available, either because we're protecting their health or because of a lockdown order. School closure includes physical closure. However, if there's a virtual learning offering, you can still take the leave. The rationale here is that you're expected to still attend to your children, help them with assignments, make sure they're on track, and therefore you can't do your job. Can a parent take leave if he or she is allowed to telework? Yes, but only if childcare conflicts causes the parent to be unable to telework. So if you're able to do your job from home, you're not going to be able to take the leave. However, if it's so difficult for you to do your job at home, then you should take the leave. And I'm hearing this a lot from my clients. Oh, my employer is telling me I can work remotely, so they don't want to give me the leave. And that's really not up to the employer to decide. It's up to you to decide what's suitable for you and if you're able to maintain teleworking. However, if your kids are, let's say, older teenagers, it's going to be very difficult to justify your need for this leave because they should be fairly self-sufficient. I apologize for these non-representative pictures because I've never looked this happy working with my toddler on my lap. I couldn't find any of like toddlers jumping on the laptop, but if anyone has pictures like that, I would love to incorporate them into my slides. So this is an exciting part for me as an activist for women, because a parent can take the leave on an intermittent basis, meaning you don't have to take a full 12-week break, because that can feel really daunting, right? It's like, just taking a 12-week break right when my organization needs me the most. So ask for 2 weeks. Ask for a part-time schedule. Say, hey, can we try a part-time schedule for 2 weeks and then reassess, so that you remain committed to your employer while taking the time you need for your children. And I really encourage you to do that. You can try a reduced schedule, or you can try less than 8-hour increments. Your employer does have to agree to this schedule, but I'm seeing that they're more inclined to grant intermittent requests than a full leave. Sometimes they're giving you a hard time over full leave as opposed to a part-time schedule. The Department of Labor actually encourages employers and employees to collaborate to meet mutual needs. So they're pretty much telling you, do whatever you want, figure it out. We don't care. Just do whatever works. So you want to really use this intermittent option if you can. What about a couple that has kids at home? Can they both take the leave for the same kids? Yes, but not the same period. So this is not supposed to be intended as a bonding leave where the whole family gets to stay home and enjoy time off. This is really supposed to be a leave to take care of children who are unsupervised. So if no one is able to watch these children, then you can take the leave. However, if your husband works from home and is able to watch the children at the same time, you cannot take the leave. You really have to make sure that there's no one to watch your children, but you can alternate with your partner. So you could take the mornings and then your partner could take the afternoon, so that you can both attend to your children and remain committed to your jobs. How do you request the leave? So this is also very new, because usually with these leaves, you have to submit a form. There's this whole process. And in this case, you pretty much just email management or human resources and you provide your name, the date for the leave, the reason for your leave, the name of your child, the name of your school or provider that's unavailable, and a statement that no other suitable person is available to care for your child. So that's really it. And it's very straightforward. A lot of employers won't really believe this. These sorts of laws usually don't get rolled out in the middle of this economic pressure. So a lot of the employers are actually pretty shocked. So you want to be ready to educate your own employer and cooperate with them and say, hey, there's these new rights. I think I'm eligible for them. Can we sit down and look at them together? Isn't it true this covers my situation? How can I remain committed to you while I also tend to my children who need my care? So I can hear a lot of you say, and my clients have told me this before too, like, okay, this sounds nice in theory, but these requesting a leave like that is really scary. I mean, who's going to ask for privileges in the middle of this economic turmoil where maybe you won't find a job if you get fired? And I first want to really validate that, because it's a very scary feeling right now to ask for something that a man without kids doesn't need to ask for. But I do want to tell you that these are not privileges, these are rights. And what happens when you assert a right is that you're actually in a protected class. So you are able to, when you're able to assert a right, you may not be discriminated against, you may not be fired for requesting the leaves. And what I've actually seen happening with a lot of my clients is that they don't want to take the leave because they're so scared about the impacts of their careers. However, then they're not able to meet the obligations of their employers. And then they do get terminated because they're unable, due to their kids being home, to fulfill the essential functions. And that is a legal, legitimate reason to be terminated. So if you find yourself so overwhelmed by the demands of your job, because if you've kids at home, it may actually be better to take a leave, because then you protect your job. You may not be asked to work during your leave except for minor tasks like, hey, what's the password to this portal or something like that. After the leave, your job has to be returned. You may also be given a substantially similar position. And there is an exception for employers with less than 25 employees if the position no longer exists due to economic pressures and the employer tried to find you an equivalent job and makes an effort to reinstate you within a year of the job becoming unavailable. So you essentially have to be put on a non-rehire list. Okay, so let's address the issue of not being eligible. The first one is if you work in healthcare. So you want to be very clear with your employer that this is an optional exclusion. Healthcare is also clearly defined in the Act. So you want to ask your employer, hey, do we fall within that definition? And if you can use FMLA, but only if you or your child has a medical condition, if you're eligible for that. If you work for a small business and they're telling you you're not eligible, you really want to ask your employer, okay, why is that? Because there's very specific guidance in the Act where giving you the leave would be an extreme risk due to financial health and operational capabilities. They really have to justify that. You can also talk about the PPP, which is a program that gives employers money to keep people on payroll, and it can also be used for people on this leave. For small businesses, you can use another qualifying reason for the sick leave, like a lockdown order or like having coronavirus. If you work for a big employer, you want to know that this is currently being negotiated through the HEROES Act. We don't know yet what's going to happen, but we're hoping that this will be expanded soon. In addition, a few cities have expanded this, San Francisco, LA, and San Jose, so you want to look at your local ordinances. You want to use a legislative reason for the exclusion. So they, for example, what they told employers of this size is that they expect them to give the leave regardless of the law. And that's something that you want to use. You can also use estate leave. So these are federal rights, and you may actually have rights under your state regulations that you're able to assert. The rights you have under the FFCRA, you have on top of any state rights. What if you've already taken FMLA in the last year? And now we're going to move into more of the pregnancy and postpartum topic. So the emergency family leave is an expansion of the FMLA, and you can only take one FMLA per year. So you can't take another FMLA or another emergency family leave in another if you've already taken an FMLA. You can take the emergency sick leave, so the 2 weeks. You can also take any state leaves that you have available to you, and then ask for your FMLA maternity leave to be reclassified. This is a little complicated, but it's something I've done with my clients so that they're able to actually take an FFCRA leave. And you can also ask for a reasonable accommodation, which we'll go into in a little bit. You want to know that FMLA eligibility is different than FFCRA. So it's possible that you're eligible for FMLA and not FFCRA, or that you're eligible for FFCRA and not FMLA. So the FMLA eligibility requirements include that you need to work for an employer with 50 or more employees. You need to have worked there at least a year, and you need to have worked there for at least 1250 hours. So this means that if you work for a large corporation, more than 500 employees, you're eligible for FMLA and not FFCRA. If you work for a small employer, you're not eligible for FMLA and you are eligible for FFCRA. I know I wish they made this a little easier, but what I'm trying to explain is that if you're not eligible for FMLA as a pregnant woman, you may be able to use FFCRA as a maternity leave, because you can use FFCRA for reasons including daycare closures and nanny unavailability. So if you're not eligible for FMLA because you work for a small employer, or you haven't worked at your employer place for at least a year for 1250 hours a year, you can try to use FFCRA as a maternity leave. So that's pretty exciting. So this is what we just discussed, that you may be eligible for FFCRA, FMLA, and vice versa. Under FMLA, which is traditionally the disability bonding leave, there's no obligation to be paid. So if you want to choose one, you want to go with FFCRA because it's at least paid at 2/3. But just like FFCRA, under FMLA, you have job protection. There can be discrimination. It may not be denied. This is true for any sort of leave request. It may not be denied by your employer. They can't say, oh, I'm sorry, we can't make that work. They actually have to give you the leave if you're eligible, even if it's a burden to them. Also under FMLA, there's an intermittent option. More pregnancy rights and postpartum rights. So the accommodation rights. These are things like telework, flexibility, reduced schedule, and an extended leave. Let's say you're expected back at the office and you have a baby at home, or you're pregnant and you don't want to be exposed to COVID. You can request a reasonable accommodation to continue to telework. And if you've been doing your job from home, there's no reason that it can't be granted, right? Because you've already proven you can do your job from home. All you would need is a doctor's note. So your doctor has to confirm that you really should be home. You shouldn't be at the office. So you have to work with your employer and you have to work with your doctor. Different states have different minimum employee eligibility. It can be between 5 and 15. So you want to check your state rights. I want to talk about reopening. I've seen a lot of people who are expected back at work. That's really not up to your employer to decide. So we have to follow our state's lockdown orders and our city's lockdown orders. In a lot of places, we're not at the stage yet where all businesses can reopen. And even the federal guidelines encourage teleworking. So you want to be very clear with your employer and even send them the orders and say, hey, I don't think we're supposed to be back at the office. I've been able to work from home. Can I continue to work from home? Because I think pursuant to these state orders, we should be continuing to telework if that's at all possible. Let's talk about your safety rights. So you are entitled to a safe and healthy work. You're protected from retaliation for lodging safety concerns. So if you go to your employer and say, okay, this person next to me has COVID, this is extremely dangerous for me to be here, your employer has to address that. Now, does that give you the right to stay home? Not necessarily. So the safety rules don't have a leave of absence right. It just gives you the right to be in a safe work environment. And then it's up to your employer to make sure that your environment is safe. So this is a presentation. I encourage you to follow me on Instagram or Facebook at The Mom Attorney. I'm going to put my resource library into the chat box and go through a couple of questions. I cannot give legal advice through this forum, but I do encourage you to talk to me individually if you need to, and the information for that is on my website. And I really would love for you to share this information because there are so many parents who just don't know that they can take a leave of absence and then they're close to leaving their jobs. So if we can put their jobs on hold, or at least make sure they have some time during the day to attend to their kids, it's going to be huge to help us save and salvage these jobs. A lot of us don't feel safe sending our kids back to certain schools. So we really want to make sure we use a tool of the law to protect our kids. The law gives us a roadmap. It tells us, okay, these are my rights. This is what I can do. And when you have the law on your side, you feel really confident in your ask. Even if it's difficult, at least you know, okay, the law is on my side. So, I know this is really difficult, and legal stuff can be another emotional labor burden you don't want to deal with. So feel free to look at my articles so that you really know what your rights are. The fact that we're doing this with our kids, it's really incredible. And I just want you to know that you're so powerful. And I want you to keep moving forward in your career if that's what you want, because what we're doing right now, that's leadership, attending to these kids, doing our jobs, trying to figure everything out at the same time. It's really hard. And I'm very proud of you for doing this. Let's all work together to keep moms employed so that we can show our children how amazing and powerful we are. And so we can show that we have agency over our own careers, that we don't feel like we have to leave our jobs if we don't need to, even now. We want to use these new rights that are available to us so that so that these laws become ingrained in our new economy. This is a right that is specifically given to parents, putting parents in a protected category. It's extremely exciting. Under usual circumstances, it would be hugely celebrated, but there's so much happening right now that a lot of people just really don't know, and it's hard. It's been implemented really fast, and there hasn't been any training on it. So you just want to make sure that you know that these are your rights. They're here to protect your families first. And I'm here if you have any questions. I love serving you. I love serving mothers and helping them in their careers. And thank you so much for looking at my webinar today and being here. And I know you're so busy and you probably have to go and make grilled cheese. I'll run through the questions a little bit, but again, I can't give legal advice. So does the law include a situation where employers already pay time off? So if you have a PTO policy, this law can be used on top of your policy. So if there's sick, for example, if there's sick leave policies, they can't use this emergency sick leave in lieu of your sick leave policy. You actually have to be able to use both. What they can do is use your PTO for that 2/3 to supplement the 2/3 pay. So you can use your PTO time to get to a full 100% pay. So that's something you can do. If you don't want to take a pay cut, you can use your PTO to top off the 2/3 of your pay. So employers larger than 500, they do not need to offer the leave, unfortunately, under the law. However, many do, and you want to check your policies, and you really want to also work with your employer. And I tell a lot of my clients, like, even though it's not a right, you still have to ask for it. You still have to ask for it, even if it's not a right. You still have to go into management and say, hey, can we work on something together? What I also tell a lot of my clients is to look for other parents, so that you go in collectively and it's not just you, which is really scary, but as a group, you go into management and say, okay, this is what we need. This is our plan. You want to make it as easy as possible for your employer, that they just have to say yes. What happens if someone takes leave and then the company has to furlough or lay people off? So the leave is only available to those who are still employed. People who are on furlough may not take the leave. If you're on leave and then you get furloughed, you want to look at, they may do that. That may be legitimate as long as it's a big group. If it's just you, I would look into that, because that seems suspect. That seems like a discrimination issue. But if you're part of a layoff group and furlough during your leave, that's possible. Do you know how long the employer has to make those safety changes? So the safety rules have been our laws for a really long time. The safe and healthy work environment is part of the OSHA network. So these are the rules that have already existed and now are kind of extended to include the COVID situation. And there's specific guidance for employers on how to protect employees from COVID. Those are usually the EEOC rules. Okay, these are the questions today. Thank you so much for being here, and thank you for listening, and thank you for being willing to be educated. You're all warriors for justice. Help me spread the message, and I love you, and you're doing a fantastic job. I'm so proud of you. Keep doing what you're doing, because we're doing it. Even though every day we're saying, oh my God, it's too much, you're still doing it. Every day you're doing it. So we'll just keep going, and we're in this together. You're never alone. Thank you. Bye-bye.